NACDL is the association of the nation's criminal defense bar.
Talking about a few examples and ideas of developing a theme. We've heard over and over the importance of doing that. We certainly got a very good example of that yesterday afternoon in the discussion of the James Holmes trial and the desire to get the mental illness there, but worried about how the jury would treat it at the guilt phase, how they would apply it at the penalty phase, and the importance of communicating to the jury what the mitigation was, how it was to be considered in mitigation, and so forth. So I want to just talk a little bit about that, and particularly about, because we don't have much time, talk about what I'm particularly concerned about, which is children and dealing with childhood and how we can relate our issues or our mitigation about the mitigating factors in the lives of our children and our clients to jurors in their concern about their own children. The number of death sentences in this country has dropped tremendously from around 300 at one time to about 40 a year now. And I think there's several reasons for that I just want to touch on quickly. One, better plea bargaining, which you heard about yesterday and is so critical. I see in Georgia we went 5 years without any death sentence. It wasn't because the cases were necessarily going to trial and being decided by juries. It was because of good plea bargaining by our Capital Defender Office, taking the fight to the prosecutors, taking the patience and time it took to the clients. I think a second thing is life without parole. It is enough. It is possible to convince people that it is enough. Almost every state, I think every state now that has the death penalty has life without parole as the alternative. That was not always the case at one time. In some ways, it's too bad that we have life without parole. There it is. But on the other hand, in terms of our cases, it is making quite a difference. In Georgia, we have 3 sentences: death, life without parole, and life with parole. And the courts have held that jurors have to be able to consider all 3. And in jury selection, since we went to this, I found that there are far more people who cannot consider life with parole than there are people who cannot consider the death penalty. And it's been a very effective way to get a lot of pro-death penalty jurors off. They say, yes, I could give this guy the death penalty for what he did. I could give him life without parole for what he did, but I could never, ever give life with parole for the terrible crime that was committed here. Thank you very much. We'll see you later. You're out of here. Alabama next door, life without parole and death. No third alternative there. And I know there's some places where there are even 3 or more. Concern about innocence has been a big factor, not always in every case, but it certainly caused, I think, overall there to be concern. And of course, cost has been a big concern, particularly in communities that cannot afford it. I think the other factor is the inevitability that a lot of people just think the death penalty costs too much, takes too long, re-victimizes the victims, and really is not serving any real law enforcement purpose. And that there are a lot of places ready to move on. But most critically has been the effective presentation of mitigation and the change that has taken place over this period of time with regard to that. In the 1980s and 90s, in a lot of states where I practiced, Alabama, Georgia, Mississippi, Louisiana, Texas, nobody knew what a mitigation specialist was back in those days. Since a certain point in time, probably in different places, everybody knows, and everybody knows it's absolutely indispensable in a capital case. And that's a huge, huge difference in terms of the resources that are available, the investigations that can be done, the sensitivity that judges and others have to the importance of mitigation and what has to be done. I remember so many cases in the early days after the death penalty was reinstated in 1976, where everything went into the guilt phase. And then the penalty phase was almost an afterthought. And of course, today, we know the importance from the very minute we get these cases to start looking into the life and background of our clients so we can put on things in mitigation. But the big challenge, as several people have mentioned, is how to get the jury to consider it as mitigation. We talked about earlier today some of the double-edged sword with regard to drug addiction, some mental illness, other kinds of things, that jurors may not view those things as mitigating factors. And so we have to figure out how are we going to convince the jury that they are mitigating, from jury selection to the guilt phase to the penalty phase, all the way through. Several people have mentioned Scott Sunby, whose article, A Jury Considers the book, and the article that Mark Bookman mentioned yesterday. One of the things he talks about there are jurors who said, well, we got all this information, and it was sort of dumped in front of us here, but we didn't know what to do with it. So we really couldn't figure out where it sort of went into the mix of things. And we know from his work and others in the National Jury Project that some jurors think that once they find an aggravating circumstance, that's it, that they've got to impose the death penalty, that they're required to impose the death penalty. So one of the most important things we have to make sure that all our jurors understand by the time jury selection is over, as was talked about earlier today, is that the death penalty is never required, that they always have the option of imposing a life sentence. And that each juror makes an individual decision about that, makes an individual decision about mitigation, makes an individual decision about considering the two together, and the ultimate decision about what ought to be done. Here are a few thoughts that I have. One, I think as we think about this, we want to think about defining the issue. So much in the world today is, how do you define the issue? And depending upon the answer to that, should we have health care for all? Most people might say yes. Should we have socialism? Maybe not so enthusiastic about that. We know that the way questions are framed makes a big difference. There was a senator from Arizona many years ago, Carl Hayden, and late in his career, he was running for re-election, and the rumor circulated that Senator Hayden was dead. And actually he wasn't. He was in pretty bad shape, but he wasn't dead. And he called the media into his hospital room. He lifted his hand up off the bed and dropped it back down again. He got reelected because he wasn't dead. They had defined the issue in a way favorable to him. And the way the prosecutor is going to define the issue in our case is, should we have the death penalty for this crime? And if that is the way the issue is framed up, that is usually not going to work out well for us. If the question, on the other hand, is this person so beyond redemption that they ought to be eliminated from the human community? Is there a glimmer of humanity in this person? Do we all agree that death is the absolute last resort? That we don't kill except as a last resort? We don't go to war except as a last resort? Then that's a very different way to look at it and to analyze the issue. I think we can't make it clear enough in talking to the jury. This is not about forgiveness. It's not about excusing or justifying. There is no excuse. There is no justification for what happened. It's not about escaping punishment. The punishments that are before the jury are the two most extraordinary punishments that the law allows: the penalty of death or the penalty of life imprisonment without parole. And the jury is only going to decide this: no matter what happens to this man sitting here, he is going to die in the custody of the state. And the question is he going to die because he's going to be put down, tied down and put down, or is he going to die when the God comes for him, when his time comes? I think in developing a theory of the case, trying to figure out what is that soundbite, what is that sentence or two that tells the jury what we're trying to communicate about why this person is not so beyond redemption that they have to be executed. The best example that I think of is Mike Tiger when he was representing Terry Nichols. Terry Nichols was a co-defendant of Timothy McVeigh in the Oklahoma bombing. And right from the start, not even before jury selection, when he was appointed as counsel, Mike Tiger said to the media, Terry Nichols was trying to live a life, not build a bomb. He was trying to build a life, not a bomb. And that's what he said all the way through the case. When it came to the guilt phase of the trial, he told the jury an opening statement, told them with the evidence they put on, told them with the closing argument they gave, he was trying to build a life, not a bomb. In other words, he was trying to build a life. He was a guy that didn't have a whole lot going for him. He had Asperger's, and he was limited. And this no good Timothy McVeigh came along and sort of pulled him into this thing, but he wasn't part of that. He was really trying to build a life. Now, that didn't prevail at the guilt phase, but the argument was that he could be convicted of a lesser included offense. But then when the case goes to the penalty phase, once again, he has the argument he was trying to build a life, not a bomb. And that's a reason that you would sentence him to life imprisonment as opposed to the death penalty, even though 168 people were killed in this crime. And remarkably, not only did the federal jury do that in the case, but so did the state jury when he was tried at McAllister in the state court after that. Now, that's probably better than we're going to have in a lot of cases, but I think what we want to think about is what are the reasons this person's life should be spared. If you were just talking to somebody over the back fence or over a cup of coffee, and you were talking about the case, why is it that this person, given the terrible thing that they did, maybe given the terrible record that they have, and that Mark Bookman talked this morning or yesterday about a client who had a prior murder. We often have clients who have a long history, so we have to deal with all that. We have to deal with, well, what about all the other people that went through things just as horrible as our client did, but they didn't kill anybody. They didn't go on a killing spree. They didn't do all these things. And all of those tough questions we have to ask. And what can there are going to be some common themes that we're going to have, but my big point on this is that boilerplates work for the prosecution, but they don't work for the defense. If you're the prosecutor, you can get up and talk about how terrible crime is, how great the death penalty is, how people like this ought to be executed, but we have to be very client-specific and case-specific. But there are some universal themes. He will be punished. There's no question. He will be punished. Nobody is escaping punishment here, and it's important to get that off the table. The community will be protected. Life imprisonment without any possibility of parole will protect the community from any further acts by this person. Hopefully, you have evidence so that you can say he has taken responsibility. He's taken responsibility for what he did, and hopefully, the next question, he has expressed remorse. You heard the minister testify, and you heard him talk about how remorseful he is, how terrible he feels about what he did, how he'd like in some way to atone for what he did. Now, that's something you put on the scales when you're deciding punishment. So we want to try to develop themes that are consistent, that deal with the aggravating circumstance, and all the other bad evidence that's out there, and makes the mitigating case more convincing, and I think provides the jury with a structure. As was also said before now, very often the jury instructions, nobody understands them at all. And so the question is whether, at least my thought, in jury selection, as well as during the trial, can we give the jury a structure for how they're going to make the decision of whether another person is going to live or not. And one part of that, of course, is expressing the enormity of that decision that they're going to be making. That no matter how awful the crime, no matter what the record, as Craig Haney has pointed out in his writings, very difficult to get 12 people to sit down and make a premeditated decision to put another child of God to death. And the more they know about that person, the more, as we know already, the more the humanity of that person is brought out, the more and more difficult that it is going to be. A couple of years ago, a very mentally ill guy tried his own case in Georgia, death penalty Georgia. Fired the lawyers, wouldn't take any advice from the lawyers, insisted on going to trial. It was a police officer killing, terrible case. And we all thought, well, this is bad, and this is going to be a disaster. And it went on for about 2.5 weeks. And everybody was sure what the verdict was going to be, but the verdict was life imprisonment without parole. And I think the reason for that was the jury saw that guy up close and personal so much over that 2.5 weeks that they really understood how mentally ill he was, because he was profoundly mentally ill, and that was very obvious in everything he did. We had another case about 2 years before that where some fellow got on the witness stand. The defendant testified and not only told about everything he had done in that crime, but told, much to the prosecutor's delight, about a lot of other things he had done that weren't even alleged or charged or whatever. And somebody that saw it, I wasn't there, but somebody that saw it said it was the rawest thing I've ever seen. I mean, this guy just, he was crying, he was this, he was that, he was the other. And the jury, I'm not recommending doing either one of these things, by the way, far from it. But in that case, too, the jury came back, did not impose the death penalty. And again, the only reason that we were able to figure out about that was that they really got a very good sense of just who this person was, and it became much harder to kill him. A couple of books I recommend. One is Craig Haney's book, or the Law Review articles. They're cited in the handout for this. And the other one is Lieutenant David Grossman's book, which some of you may have looked at, On Killing, which is about how you convince people to kill. Normally, most people, as I said, most people don't want to kill another person. And both Haney and Grossman talk about how that you dehumanize people, you formalize the process, you convince them they're just a cog in the system, that really they're just doing their job, just like a soldier on the battlefield, just like a pilot dropping bombs from the airplane, and that to the extent that we can bring people up close and personal to this decision, the enormity of this decision, the fact that this is a human being's life that is in their hands, and that nobody else, ladies and gentlemen, you may know that when there's a firing squad, one person in the firing squad may have a gun that has a blank. So that after the firing squad and after the execution is over, each person will have the solace of knowing they may have had the gun that didn't have a live round in it. But there are no blanks on this jury. Everybody who decides this case is going to make an individual decision about the life of William Anthony Brooks. And you talk about the Supreme Court, you are the Supreme Court today. And you're going to decide the supreme question of whether this young man lives or dies. It's not anybody else's decision. It's not the prosecutors. It's not the judges. It's not anybody else. It's your decision. And the closer we can get the jury to recognizing that, the more difficult I think it makes for them to take away a person's life. Childhood matters. And we read a lot. Alan Dershowitz wrote The Abuse Excuse, one of his dubious contributions to the law, about how we shouldn't give the abuse excuse, and we sometimes hear that. One of the cases where that was bantied about a lot was the Menendez case in Los Angeles, the kids that killed their parents. And one of the things that was talked about on talk radio was how part of the evidence in the case was that the father had torn the head off the teddy bear of these little boys. And that was seen as just sort of a joke. Let me tell you, you may think when you call talk radio that tearing up a little boy's teddy bear doesn't amount to anything, but you take any mother and father and threaten to go in their nursery or their child's room and tear up one of the most loved things that child has, the teddy bear, you see how long they're going to put up with that. I mean, we know that those kind of things are extremely upsetting for children. And we try to protect children from that. We try to protect children not only from things like that, but from violence, from being a victim of violence, from seeing violence, from experiencing loved ones with it. And we know that makes a difference because everybody, as parents, tries to protect their children with regard to things like that. The prosecution will talk about free will. Everybody has free will. Well, first of all, that's obviously not true. But secondly, no matter how many choices people make later in life, nobody chooses their childhood. Nobody chooses to be born with fetal alcohol syndrome because their mother abused alcohol or drugs during the pregnancy. Nobody chooses to be schizophrenic. Nobody chooses to go through a childhood of trauma, abuse, seeing violence, and all those kinds of things. When we tell our story, we can tell the story of that and then compare it to what we would want and what we do for our children every day. Some of my friends who read my closing argument say, gosh, I didn't even know you had children. Well, I don't, but I do when I'm sharing my thoughts with juries. Because we want to think together about this. We want to think together. I tried a case in Morgan County, Georgia, and I found out during the jury selection that there was an organization there called the Morgan County Men's Club. And it was a group of African American men who tried to help young black boys primarily growing up. And several of the jurors told us about it, and fortunately, some of them were on the jury. And so we're talking about the closing argument, we're talking about, right here, I know some of you are a part of the Morgan County Men's Club. But if I understood it from the discussion we had of this in jury selection, what you're trying to do is intervene on behalf of people just like little William was. You're trying to make sure that if he doesn't have the parental support, if he doesn't have people looking out for him, you're going to look out for him. And you're going to teach him how he can come along in school, and he can come along in sports, and he can come along in life so that this kind of thing doesn't happen. You know it makes a difference because that's why you're doing it for these children. Mark was talking about yesterday that sometimes the expert witnesses are not nearly as good as lay witnesses, and I can't endorse that enough. My view is we got to just spend as much time as it takes going to all the places that it takes, talking to all the people that there are to find those people. Every family has a snitch. Every family has a snitch. A lot of times it takes a long time to find that person who will spill the beans. But the other thing is, every family usually has a storyteller. Somebody that you can sit on the front porch and the swing or the chairs and they can tell you about what happened. And they can tell you the truth. I tried a case a couple of 3 years ago, Jamie Weiss, case out of Georgia case, but had grown up in West Virginia. And I spent a huge amount of time in Princeton, West Virginia, and going back in the hollows and the mountains and talking to all of his aunts and his cousins and everybody that I could find in that community that knew anything about him or his family or whatever. The case was, or the point, one point I'll make, there were many points, but one was that his mother abandoned him very early in life. And ran off and tried to run around with some other people. She ran around with a lot of people, and she wouldn't even acknowledge him. When they would be in town and she saw him, she would be trying to get with these other guys, so she wouldn't acknowledge her own son at all. You don't need a child psychiatrist or psychologist to tell you that's not very good for a child growing up. But of all the people in the family, and the mother had plenty of other problems, which we don't have time to discuss here today. It took a good bit of closing argument, a good bit of trial to go through them all. But Aunt Barbara turned out to be the person, mother's sister, who not only was willing to pony up to the truth, and a lot of the other sisters weren't willing to pony up to the truth because it was incredibly painful. It was very hard to get them to talk about things that they'd been trying to forget for 20 years. But Aunt Barbara was very engaging. Not only that, when I called her to the stand, I asked her if she was undergoing treatment at the time, and she was, chemotherapy for her breast cancer. Would that affect in any way her ability to testify? No, it wouldn't. But I expect the jury paid a little more attention to Aunt Barbara after they heard that fact, and they probably connected with her a little bit more. And then she just laid it out there. So I tell the story, first of all, in jury selection. What we expect this case is going to be about is you're going to hear and describe that to some extent. Describe it again in an opening statement at the penalty phase, tell the whole story and more. Have Aunt Barbara tell the story when we're putting on our evidence, and then in closing argument, go back to Aunt Barbara's story again. So as Tammy was saying yesterday, the jury hears it over and over and over with regard to what happened. I did not call several other people who were members of the family, other sisters, because they just couldn't pony up to the truth. So there's selection involved in what witness are we going to put on, who's going to tell this story, and how well is that witness going to be able to do it. And how do we get people to accept that evidence? Yesterday, you saw those films of the videos from the jail, and how compelling that was. Sometimes you just find those things. Sometimes you don't, but when you do, it can be very helpful. Supreme Court case, Terry Williams case out of the United States Supreme Court, finding ineffective assistance of counsel for failure to put on mitigating circumstances. Look at footnote 14 in that. It was a report by a social worker who had been to the house and had written a report, and it's one paragraph, and it obviously really had an impact on Justice Stevens because he put it in his opinion. And it was a social worker saying that the home was a complete wreck, that there were places all over the floor was covered with feces and urine and clothes. The children were unclothed or partially clothed. None of them had on any underwear. The parents were so drunk that they couldn't put the clothes on the children or do anything with them. The children had to be put in the hospital, and they were all under the influence of whiskey. Just a little paragraph. What a picture of Terry Williams' home when he's growing up. And the capper on that was the family, the parents, got prosecuted for criminal neglect of their children, were convicted, put in prison, and when they got out of prison, they gave Terry Williams back to the parents who had been convicted of criminally neglecting him. That's not Terry Williams' fault that happened. And that was obviously compelling to the Supreme Court with regard to that. Sometimes we just have to have witnesses tell the stories, and we tell the stories. That this young man, when he was 4 years old, you remember the testimony, that he would come downstairs in the morning and the most important man in his life was bringing down the spike of a high-heel shoe on the head of the most important woman in his life, his mother. And he stood there at 4 years old, and he's crying, and he's wetting himself, and he's terrorized by what's happening. The next morning he comes down and his mother unloads a full pot of coffee, hot coffee, scalding coffee right on the father's face. This went on every day in this house. One day his sister fired a shot from a rifle at her father. What kind of place is this for a child to grow up? We wouldn't want our children to grow up like that. You know, the other day I was over at my sister's place, and my little nephew was getting ready to go to bed, and before he went to bed, before my sister took him up to read him a story and say goodnight, he went around the room and he kissed his dad and hugged his dad. He gave me a big hug. He goes to Uncle Sally and gives her a hug. He goes to every adult that's there, and everybody gives him a hug, and everybody says goodnight, and we'll see you in the morning. And you know what? That child knows. That child knows he's protected. He knows there are people that love him. There's this group of people that love him fiercely, and they're going to be there for him no matter what. That's not what William Brooks had when he was growing up. And that made all the difference in the world in terms of what kind of risk factors were present, what kind of things happened later on. So I think those are things that are almost you can't dispute from the standpoint of the prosecution wanting to say, one time the prosecutor said about cold, hard, and mean. I said, when did he become cold, hard, and mean? When he was born prematurely, when he was in the incubator, when he was fighting for life, was he cold, hard, and mean? Could you just have come in and put him in a microwave and killed him right then? When he was 2, 3, 4 years old, when he was in the nursery, could you come there and say cold, hard, and mean right then? And you go on through that, really? I mean, what happened? Nobody's cold, hard, and mean when they're born. Life is complicated. And we have to, I think if you're the prosecutor, you want to talk about free will, or you want to talk about moral absolutes. And if it's us, we want to talk about the gray areas in life and the complexity of life and how these things, we don't know exactly where on the scale they are, but we all know that they are an influence because we put so much of our life into protecting our children. Try to set this up in voir dire when you ask jurors things like, have you ever had to decide whether to kill another person or not? Most people haven't. Few people have, of course. If you did, would you want to know things about their childhood? Would you want to know other things and go through that? And then closing argument, you come back to the jury because the prosecution's going to say, what do they got? We've got aggravating circumstances. We've got tombstones here. There are aggravating circumstances. What have they got? All this mitigating circumstances, all this people crying for him. Oh, no. When I ask you, if you were going to have a person's life in your hands, if you're going to decide if a person lived or died, would you want to know everything? And if I remember correctly, every one of you said, absolutely, you'd want to know everything. And that's why we've told you everything. That's why we've told you about the childhood and the adulthood and everything, all this rough, terrible journey that this child has been through. Because that's all things that you take into account. Because we don't measure everybody the same. We measure people depending upon all the hills and valleys they've been through. And a person who's had every opportunity in life and goes out and commits a crime is a very different person than a person who was right from the start of their life punished in every way imaginable. We try to keep our children away from bad influences. We try to keep them away from drugs. We try all those kinds of things that are things that people do. I always say pick the right battles to fight. Abraham Lincoln was a great lawyer, at least they say, because he knew how to pick the 10% of the case that was important, convince the jury that's important, and concede the other part of it. I advise against fighting battles we can't win. No, it wasn't really torture because he's only stabbed 9 times as opposed to a whole lot more. And I think, those kinds of things, conceding things, if you have a sympathetic victim, as we so often do, acknowledge that the victim is a wonderful person, an innocent person. Of course, this is terrible what happened. But that's in the aggravating circumstances. We can't get away from the aggravating circumstances. But my way of dealing with that is to say, well, of course there are aggravating circumstances. We wouldn't be here if there weren't aggravating circumstances. All that does is get us here. Now that we're here, we have to look and see about this particular person and the facts about this person, whether or not Jamie Weiss is somebody that ought to be put to death. Well, let me say just a couple of things separate from that in closing. I said earlier about how the number of death sentences has gone down so much. And I just want to come back and say a couple of words about that and about where I think we go from here. In the 1980s, 1990s, I was doing this work, and I felt like we were kind of like people on the Underground Railroad. We were just trying to get one person into safe passage at a time. But the death penalty seemed like just a tremendous thing. It was part of the presidential election with Dukakis in 1988 and again in 1994 with Clinton coming back and executing this kid so he could get elected. We were having almost 100 executions every year. The governor of New York, Mario Cuomo, was voted out of office because of his position on the death penalty. 3 justices were voted off the Supreme Court of California, and it looked like all hell was breaking loose, and this was going to be here for a long time. And then about 2000, all this work and all this training and all of what we've been doing started paying off, and things started changing, and we saw fewer people sentenced to death. We saw in Illinois a Republican governor who saw that there had been 12 executions and 13 exonerations, thanks to the work that Larry Marshall at Northwestern and the journalism class and so many people did. And this Republican governor who had voted for the death penalty in the legislature said, what kind of system is this? That we're maintaining a system that misfires more often than it gets it right. And then 2 great journalists wrote about the Illinois death penalty and the quality of lawyers and snitches and prosecutorial misconduct and all that. And then in 2003, George Ryan commuted every sentence in Illinois. And then the Supreme Court in Atkins changes its position. It had upheld execution for intellectually disabled people. Now it reversed that. Not long after that, Roper versus Simmons, it changed its position with children, said you could execute children, not anymore. 166 exonerations during that time. And states started reconsidering the death penalty. New Jersey, Illinois, New Mexico, Maryland, Connecticut all repeal the death penalty. Courts started striking down the death penalty in New York and Illinois and New Mexico and just this last year in Washington, in Delaware. New Hampshire just recently repealed its death statute. And we have moratoria against executions in California, Pennsylvania, Oregon, and Colorado. So we've gone from this, 315 people sentenced to death in 1996 to 43 last year. And before that, it was 39 and 31. And the number of executions has gone down from 98, 1999, to 25 last year. Here's what I want to tell you. This is all about the right to counsel. This is all about what you're doing. Because Gorsuch can write about how we're not going to grant stays anymore and we're going to move these executions on, and the federal government can reinstitute the death penalty and start executing people sentenced to death. But I will tell you, these numbers are not going to change. And it's because of the right to counsel. It's because of representation that people are getting. Look at Virginia. Virginia executed 113 people, second only to Texas. But since the Capitol Defender Office has been there hasn't been a death sentence in Virginia since 2011. There are only 3 people on death row. This is a state that executed 113 people. There are 3 people on death row. It's because lawyers are representing people in Virginia cases. We went all that time in Georgia without any death sentences. That's because lawyers representing people in our Capitol Defender Office. 5 years with no death sentences. And so what we have to do going forward is keep this up. Martin Luther King used to say, we stand on the shoulders of others so people can stand on our shoulders. And today we stand on the shoulders of a great visionary lawyer who about 100 years ago, Clarence Darrow, stood before a judge in Chicago and said, "Your honor in deciding whether these 2 young men are going to be executed stands between the past and the future. You can kill these boys if you want to, but if you do, you'll point your face towards the past. I'm asking you to look towards the future. I'm asking you to look for a time when hatred and cruelty will not rule our hearts, and when we will learn by judgment and understanding and reason that all life is worth saving and that mercy is the greatest attribute of humankind." That's pretty much where we are still today, and that's still what we're trying to carry out. We also have such a great debt to Thurgood Marshall, who traveled all over the South and represented people in death penalty cases. He rode on a train when people were trying to lynch him. He came very close to being lynched one time. If you haven't read Devil in the Grove, marvelous book by Gilbert King, I highly recommend it. Be sure to get it and be sure to read it, because it's a marvelous story about Thurgood Marshall and about his going to Groveland, Florida in 1940 to represent people. Thurgood Marshall once took a train from Washington, D.C. to Oklahoma City and then took a bus to Hugo, Oklahoma to represent somebody in a death case. Can you imagine? These 2 books I recommend as well. One is Anthony Gray's book called Infinite Hope, and it's got a subtitle so long I won't even begin to lay it out. And then Anthony Ray Hinton's book, Brian's Client, who just got out a few years ago, The Sun Does Shine. Both of these books, innocent men arrested, and they tell their mothers, "Mama, don't worry, I'm going to be back. We're just going to go downtown. We're going to straighten it out. It's just a mistake. I'll be home tonight for dinner." And then they get down, they try to cooperate every way they can. Want me to go in the grand jury? Absolutely, I'll take a polygraph? I'll take a polygraph. And then as you read the books, you see how this all turns into this huge nightmare for these 2 young men. If you haven't visited what Maury talked about a moment ago, this is the Memorial to Peace and Justice. This is the lynching memorial that Brian Stevenson and others at EJI put together. It's absolutely someplace where you want to go to see that, and also to go to the Legacy Museum, which is from slavery to mass incarceration, along the way, convict leasing, peonage, Jim Crow, and all those things. We want to be grounded in our history, and we want to be inspired by those who went before, so that we can keep on making the case for life until the time comes when we'll finally make permanent, absolute, and unequivocal the injunction, thou shalt not kill. Thank you.